If you are a green card holder, a lawful permanent resident, or someone closely following United States immigration news, you may have recently come across alarming headlines spreading rapidly across social media and online news platforms. Several posts claim that green card holders must report to government offices by March 15th or risk removal from the United States. For many immigrants and their families, those headlines sound frightening and urgent. People immediately begin asking serious questions. Has a new immigration rule suddenly been introduced? Is there a nationwide deadline that permanent residents must follow? Could millions of lawful residents really lose their status overnight? Whenever immigration-related news begins circulating online, fear often spreads faster than verified facts. Immigration status is deeply connected to a person's stability, their family's future, their employment, and their long-term plans. For individuals who spent years working toward permanent residency, even the suggestion of a sudden deportation deadline can create panic. But before reacting to viral headlines, it is important to slow down and understand the real story behind those claims. Over the past few days, confusion has grown around a supposed March 15th immigration deadline. In reality, there is no nationwide order requiring every green card holder to report to immigration offices. There has been no emergency law passed forcing lawful permanent residents to check in with the government before a specific date. Much of the panic circulating online comes from misunderstandings about routine immigration procedures and individual case notices. What actually happened is far more limited and far less dramatic than many posts suggest. Recently, certain individuals received official letters requesting clarification about extended absences from the United States. These letters included response deadlines. When information about those individual cases began appearing online, many readers misunderstood the situation and assumed the deadline applied to every green card holder. That interpretation is incorrect. A green card represents lawful permanent residence in the United States. Permanent residence means that the individual considers the United States to be their primary home. It does not mean someone cannot travel abroad. Lawful permanent residents are allowed to visit relatives overseas, attend international events, go on vacation, or manage temporary business responsibilities outside the country. However, the expectation remains that their main life is based in the United States. They maintain a home here, work here, pay taxes here, and continue building their future in the country. This principle has existed within United States immigration law for decades and has not recently changed. Sometimes travel records show that a person has spent extended periods outside the country. When that happens, government officials may request clarification to confirm whether the individual still intends to live in the United States permanently. These inquiries are part of normal oversight and do not automatically lead to deportation or loss of status. The March 15th date that people are discussing online comes from specific letters sent to certain residents whose travel patterns raised questions. Those letters requested explanations and provided deadlines for response. In some situations, the response date happens to fall on March 15th, but that date applies only to the individuals who received those letters. It is not a universal deadline for millions of green card holders across the country. If you are living in the United States as a permanent resident and you have not received any official communication requesting information, then there is no action required from you. There is no need to schedule an appointment. There is no new form to submit. There is no requirement to report to a government office before March 15th. Your immigration status remains exactly the same as before. Many permanent residents travel internationally throughout the year. They visit relatives overseas, attend weddings, handle family responsibilities, or simply take vacations abroad. These activities are normal and completely allowed under the law. Short trips lasting a few weeks or even a few months generally do not create any concerns. The situation becomes more complicated only when travel patterns suggest that someone may actually be living outside the United States most of the time. Extended absences approaching 6 months can sometimes raise questions. Absences close to 1 year or longer may require additional explanation. These situations are reviewed individually and depend on the person's ties to the United States. To understand the difference more clearly, consider 2 examples. Imagine a permanent resident who lives in California, works full-time, pays taxes every year, and owns a home in the state. Once a year, she travels abroad to visit her parents for several weeks. Her life clearly remains centered in the United States. In this situation, there is no reason for concern and no reporting requirement. Now imagine another individual who received a green card, but later moved back to his home country to run a family business. For several years, he has spent most of his time abroad and only visits the United States briefly once or twice each year. In that situation, records may show that his daily life is no longer based in the United States. Because of that pattern, officials might send a letter asking him to explain his absences and demonstrate that he still considers the United States his permanent home. If he receives a letter requesting a response by a certain date, that deadline becomes important for him personally. But it does not apply to millions of other permanent residents who never received any letter. Much of the fear spreading online is fueled by myths and misunderstandings. One common rumor claims that every green card holder must register with government offices by March 15th or risk deportation. That claim is false. There is no nationwide registration program for permanent residents. Another rumor suggests that anyone who traveled abroad recently may lose their green card. That claim is also incorrect. Travel itself is not a violation of immigration rules. When confusion spreads, scammers sometimes attempt to exploit people's fear. Some individuals may claim that immigrants must pay fees or hire services to protect their status before a supposed deadline. These scams can cause serious financial harm. The safest approach is to rely only on official communication from government agencies. If there is ever a real requirement affecting your status, you will receive a direct notice addressed specifically to you. According to USCIS guidelines, lawful permanent residents maintain their status as long as the United States remains their primary residence. Before we continue, if you want to stay informed about important immigration developments in 2026 and avoid missing critical updates that could affect your future in the United States, make sure you subscribe to this channel and press the bell icon so you receive every new update the moment it is published. Now let us talk about practical steps permanent residents can take to maintain their status securely. First, always keep your green card valid and renew it before it expires. Starting the renewal process early is recommended because processing times can sometimes take several months. Second, if you expect to remain outside the United States for an extended period, consider applying for a re-entry permit before leaving the country. This document confirms that your absence is temporary and that you still intend to maintain permanent residence in the United States. Third, keep records that show your life is based in the country. Documents such as tax returns, employment records, lease agreements, mortgage statements, and school enrollment records for children help demonstrate that the United States remains your primary home. Most permanent residents will never be asked to show these documents. However, having them organized can provide valuable reassurance if questions ever arise. It is also important to understand that immigration law recognizes real-life circumstances. Families face emergencies, relatives become ill, and sometimes people must remain abroad longer than originally planned. An unexpected delay outside the United States does not automatically mean that someone has abandoned their residency. What matters most is the individual's intention and their continued connection to the country. Evidence such as tax filings, employment letters, bank accounts, and housing agreements can help show that the person still considers the United States their permanent home. Each situation is reviewed individually, and people are normally given the opportunity to explain their circumstances. According to guidance published by the Department of Homeland Security, maintaining clear ties to the United States helps demonstrate continued permanent residency. Looking at the broader picture, the immigration system operates through structured procedures and legal protections. When questions arise about someone's status, the person normally receives an official request for clarification. They are given time to respond and provide evidence supporting their case. This process ensures fairness and transparency within the system. Immediate removal without warning is not how the process typically works. For many immigrants currently waiting for green card renewals, visa approvals, or citizenship interviews, dramatic headlines can feel unsettling. Processing delays and policy updates sometimes create uncertainty, but rumors often exaggerate the reality. The most reliable way to stay informed is to follow verified sources and pay attention only to official communication addressed directly to you. At the end of the day, the truth behind the March 15th rumor is simple. There is no nationwide reporting requirement for green card holders. There is no sudden crackdown targeting lawful permanent residents who are living normal lives in the United States. Only individuals who receive direct letters requesting explanations about extended absences must respond by the deadline listed in their correspondence. For everyone else, daily life continues as usual. Permanent residents can continue working, raising their families, traveling responsibly, and contributing to their communities without fear of a mysterious nationwide deadline. Immigration headlines will always attract attention, and rumors will continue to circulate on social media. But understanding verified information is the most powerful way to protect both your legal status and your peace of mind. According to official USCIS policy resources, lawful permanent residents remain secure in their status as long as they maintain their primary residence in the United States. If this explanation helped clear up the confusion and gave you peace of mind, consider subscribing and sharing this update with others who may be worried about the same news. Staying informed together is one of the best ways to face immigration uncertainty with confidence.